Good afternoon, everyone. My name is Kristen Salas. I'm one of the mentor attorneys of the Dallas Volunteer Attorney Program. Thank you for joining our presentation today on an overview of petitions for non-disclosure. For those of you that are not familiar with DVAP, as we're affectionately called, we're a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our goal is to match low-income Dallas residents with private pro bono attorneys that will work their case from start to finish. Our only venture into the criminal world is in the areas of expunctions and non-disclosures, which is actually a civil case that's filed in a criminal court. And right now, the DA's office is gearing up to do an expunction expo. And if you have any interest in this area, I do encourage you to sign up to volunteer for that. They're needing a lot of attorneys to help folks with expunctions. But since they're only doing expunctions, the other side to this is non-disclosures that DVAP can help folks with. And today we are blessed to have Felicia Kearney and Scott Wells to talk to us about how to do petitions for non-disclosure. Felicia is now, as of a few months ago, Assistant Public Defender with the Harris County Public Defender's Office in the Felony Division. She received her JD from Thurgood Marshall. She was an assistant district attorney in Galveston and also for the majority of her career in Dallas. Here she was the chief of the Animal Cruelty Division and the Community Prosecution Division. And she also started the non-disclosure unit at the DA's office. So we are so grateful for her to start that, which saved us a lot of headaches from when we had to go to individual prosecutors before that unit started. Also presenting is Scott Wells. Scott is a longtime assistant district attorney with the Felony Division in the Dallas DA's office. He's a graduate of Syracuse University in New York and was also, before he came to Dallas, assistant district attorney in Syracuse and Atlanta. So without further ado, I will turn it over to Scott and Felicia.
Hey, thank you guys very much. It's good to be with you all. Ms. Kearney and I are very happy to present to you this information about non-disclosures. Again, if we'll do the best we can to go through our presentation and remain within the time frame, and hopefully at the end of it all, if anybody have any questions, we'll be available to answer your questions. That could be posted in the chat section of the Zoom call. I imagine, through COVID and everything else is somewhat standard practice. So I imagine you guys understand what I'm talking about. So Ms. Kearney, we'll let her get started. It seems like we're having some computer issues if she doesn't. I think Ms. Kearney, you need to unmute yourself.
Okay, can you hear me?
We can hear you. We can hear that beautiful voice. Go ahead and take over.
Thank you. I have to switch devices, so I'm accessing it through my cell phone. So because for whatever reason, I'm having a bad connection on my laptop. So welcome everyone to an overview of petitions of non-disclosures. Scott and I are excited as always to come and present to you this topic. And so as Scott said, we're going to try to get through everything within the time allotted. And if you have any questions, please feel free to ask us. You can either ask us during the presentation or after the presentation. Okay. Scott, I might have to have you move the screen for me. Okay, so our objectives this afternoon or this morning is to develop a basic understanding of the rules and guidelines that govern non-disclosures for felony and misdemeanor cases, and for everyone to understand how to properly handle felony and misdemeanor non-disclosure requests. So what is an order of non-disclosure? So an order of non-disclosure is a court order prohibiting public entities, including courts, clerks of the courts, law enforcement agencies, and prosecutorial offices from disclosing certain criminal records. Now, the law has changed since September of 2017. As of September the 1st of 2017, the non-disclosure laws as set forth in subchapter E1 of chapter of the government code apply to all persons seeking an order of non-disclosure, regardless of the date of the offense. So if you are seeking a non-disclosure from, example, 1980, a DWI from 1980, you can file a non-disclosure. The only exception to this rule is that the automatic disclosures, and they apply only to people who receive an order of discharge and dismissal on or after September the 1st, 2017. And we'll talk about those cases that apply for automatic disclosures. So there are two base requirements. The first requirement is that you have to behave yourself. So what does that look like? From the time the individual is convicted or receive a deferred adjudication, an individual cannot receive any other conviction. I'm sorry? Scott, I'm going to get out of this because it's frozen on my computer.
Okay, do you want me to go through this slide as you do that?
Okay. Can you see me? I'm on my phone.
Yes, I can see.
Okay. So two base requirements. The first one is from the time the person is convicted or placed on deferred adjudication, an individual cannot receive any other conviction or deferred adjudication from the time the sentence is pronounced through the waiting period, except for a Class C ticket. The waiting period for felonies are 5 years. Now, the question is not only whether the person committed a new offense, but also has the person received a new conviction or order of probation. If following the conviction or order of probation and within the waiting period, a person is convicted and placed on probation for an offense committed before the conviction or order of probation, they will not be eligible for an order of non-disclosure. So I know we've seen this before. So let's say, for example, you have an individual who's charged with a felony case and on June the 10th of 2020. And then let's say on May the 10th, prior to that, they're also charged with another, let's say, a possession of controlled substance. So normally felonies are handled first. And so let's say you plead the felony out first, and then you place that person on probation. And then you close out the misdemeanor and say you plead them to time served. As a result, they will not be able to get a non-disclosure for that felony case because they were placed on probation for that misdemeanor case while they were on the felony case. So it's very important that if you have two cases, a felony and a misdemeanor, that you try to dispose of them at the same time because it could cause a problem in the long run. The other requirement is that you never can be convicted or received deferred adjudication for an offense requiring sex offender registration under Chapter 62 of the Code of Criminal Procedure. You cannot have been convicted or received deferred adjudication for any offense under the Texas Penal Code, it's number 1902, 3, 20.4, 28.02, 28.03, 22.04, 041, 25.07, 072, and 42.072. And any offense involving family violence as defined by section 71.004 of the Family Code. And please keep in mind that a affirmative finding of family violence is not required in order for an individual to not receive non-disclosure. So a judge can go behind the judgment and the facts can be presented and the judge can determine that family violence was involved. And so therefore they won't meet the base requirement of getting a non-disclosure. And so these are the offenses that are prohibited that were discussed in the previous slide, that you cannot have been convicted or received probation for any of these offenses. So we have murder, capital murder. I'm sorry.
Let me go back.
Yeah, please. Aggravated kidnapping, trafficking of persons, injury to a child, elderly individual, or disabled individual, abandoning of endangering a child, violation of certain court orders or conditions of bond in a family violence case, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case, repeated violations of certain court orders or conditions of bond and family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case, and also stalking. Okay, first-time offenders, the automatic disclosure or deferred nonviolent misdemeanor offenses, you can find that in 411.072. So we have listed all of the code references where you can find where I'm sorry, that's my train of thought. Under these codes, you can find what qualifies for non-disclosures. So deferred felonies and certain misdemeanors, you can find that under 411.0725. Deferred certain DWIs and BWI misdemeanors under 411.0726. Veterans Treatment Program, 411.0727. Certain victims of trafficking of persons or compelling prostitution. Veterans Reemployment Program, first-time offenders, straight probation, misdemeanor, 411.073. Community supervision following certain DWI convictions, conviction or confinement of certain misdemeanors, and conviction or confinement for certain DWI convictions. And so those are the code numbers or the statute numbers where you're able to find that information pertaining to those offenses.
So we have an example here just to illustrate exactly some of the information Ms. Kearney has already presented to you. And here's the example. It deals with Willie Nelson and Snoop Dogg. After performing in front of a sold-out crowd in Austin, Willie Nelson and Snoop Dogg went back to Willie's bus to celebrate their successful performances. While celebrating, Austin PD raid the bus and arrest Snoop and Willie for felony possession of marijuana with intent to deliver. Snoop tells the officers, "This is not my bus. I am here just treating my post-performance anxiety." Snoop shows the officers his prescription for medical marijuana and is released. Willie is charged with felony possession of marijuana with intent to deliver. On June 10, 2010, Willie pleads to the charge of felony possession of marijuana and receives 3 years probation. On July 5th, 2011, he pleads to charge of felony possession of marijuana he committed back in 2007. Is Willie's June 10th felony possession of marijuana eligible for non-disclosure? And keep in mind, when you read this scenario, we're dealing with probation. We're talking about deferred adjudication. This isn't standard probation, so it should read with deferred adjudication. So the question again is, on June 10th, 2010, Willie enters a plea to felony probation of marijuana and receives 3 years probation, deferred. On July 5th, 2011, he enters a plea to the felony possession of marijuana he committed back in 2007. Is Willie's June 10th felony possession of marijuana eligible for non-disclosure? No. Willie was convicted of felony possession of marijuana while on probation for felony possession of marijuana. Therefore, his June 10th felony possession of marijuana is not eligible. It deals with exactly what Ms. Kearney said. You can't have any new convictions during your time of deferred adjudication. You enter a plea of guilty for any offense that may have occurred while you're on deferred or even before. If you plead guilty while you're doing the deferred, you're gonna ruin your chances to be eligible for non-disclosure.
Okay, automatic disclosures. Automatic disclosures apply to individuals who are placed on deferred for misdemeanors other than Penal Code Chapters 20, 21, 22, 25, 42, 43, 46, 49.04, 49.06, and 71. They cannot have had any affirmative findings, no prior convictions, or deferred ever for any offenses other than a traffic offense that is punishable by a fine only. And the waiting period for automatic disclosures is 180 days after placed on deferred probation. So if a person is placed on deferred probation for 180 days and the judge signs a dismissal and discharge order on the 180th day, a request for a non-disclosure can be filed that exact same day. In order for an automatic disclosure, you can file a notice. You don't have to file a regular petition, and the notice is not required to be given to the state. Most provide evidence to the court that they are eligible, and they pay a $28 fee. So instead of paying the $300, I'm not sure exactly what it is. I know it's $300 and some change fee that is normally filed when you file a petition for a non-disclosure. With an automatic disclosure, you can file a notice and pay the $28 fee. And eligibility can be shown in a request for a non-disclosure letter. Now, keep in mind, this only applies to individuals who receive an order of non-disclosure and dismissal on or after September the 1st, 2017. Deferred adjudication. So an individual can receive an order of non-disclosure if they're placed on deferred for any offenses not eligible for automatic non-disclosures or a DWI offense. There can't be an affirmative finding. An order of discharge and dismissal is required, and the best interest of justice is what's considered. And the day that you start counting as far as in your waiting period concerned starts the day that the order of discharge and dismissal is signed. So the waiting period is, once the discharge and dismissal order is issued, is 5 years for all felonies, 2 years for misdemeanors under Penal Code Chapters 20, 21, 22, 25, 42, 43, and 46, and immediately for all other misdemeanors. Misdemeanor convictions. An individual who is convicted for any misdemeanor other than one out of the Alcoholic and Beverage Code or Penal Code 49.04, 05, 06, 065, and 71. If they receive an order of discharge and dismissal or release from confinement, including paying all fees and fines, and they don't have any prior convictions or deferred ever for any offense other than a traffic offense that is punishable by fine only, and then also they consider the best interest of justice. So the waiting period for these convictions is for probation is once the discharge and dismissal order is issued. It's 2 years for misdemeanors under Penal Code Chapters 20, 21, 22, 25, 42, 43, and 46, and immediately for all other misdemeanors. If an individual is sentenced to confinement or receive a fine only, it's immediate for fine only misdemeanors, or 2 years for completion of a jail sentence. Driving while intoxicated. Before, you were not able to get a non-disclosure for driving while intoxicated. Now you are able to. And so in order to receive a non-disclosure for DWI, they have been sentenced to deferred or straight probation or jail for a DWI offense, except under 49.04, where the alcohol level is greater than 0.15. If their alcohol level is greater than 0.15, they are not eligible for a non-disclosure. They must have successfully discharged or released from confinement and paid all fines and fees. They cannot have any prior convictions or receive deferred ever for any offense other than a traffic offense that is punishable by fine only. It is the best interest of justice is considered, and there's no affirmative finding, and the offense cannot cause an accident involving another. And it does not have to result in a major accident. If an individual gets into an accident and it's a minor fender bender, the judge can find that they do not qualify for a non-disclosure based upon the statute. The waiting period under this statute is deferred probation. Once the discharge and dismissal order is issued, it's 2 years. The waiting period for straight probation is once the discharge and dismissal order is issued. 2 years if individual was ordered an ignition interlock device for more than 180 days as a condition of probation. And a waiting period for confinement with ignition interlock is 3 years if they comply with conditions of sentence requiring an ignition interlock device for at least 180 days. And if they received, and for the waiting period for straight probation or confinement without an ignition interlock is 5 years from the date of discharge from probation or release from confinement.
We have another example for you, and we'll take a look at this. In 2010, Ms. Quinn was placed on deferred adjudication for a 3-year term for possession of methamphetamines. During her sentence, however, she was arrested and convicted of criminal mischief. The criminal mischief case stems from damage to 10 cars, a public bus, and a building, should the state oppose her petition for non-disclosure of the drug charges. Yes, Ms. Quinn was arrested and convicted of criminal mischief while on possession of methamphetamine.
Okay, Veterans Treatment Court Program. In order for an individual to qualify for non-disclosure under this program, they must have successfully completed this program. The offense did not involve operating a motor vehicle while intoxicated. And once again, the judge can look at the facts of the case and determine whether or not the offense was a result of the individual being intoxicated. They must have never previously been convicted of an offense under 42A.054, formerly known as a 3G offense or a sexually violent offense. And the court must find that it's in the best interest of justice for their case to be non-disclosed. The waiting period under this program is 2 years from the date that they successfully complete the program. During this time, an individual cannot be convicted of any felony offense. Now, please keep in mind that the county or ADA can look behind the title of the offense to see what was actually happening. With regular non-disclosures, they look solely at the offense that is sought to be disclosed and not looking at the whole arrest. But for Veterans Court, a court is able to look at other offenses as well. So for example, if you have an individual who was arrested for unlawful carrying of a weapon or possession of a controlled substance, and they were, can you go to the next slide, Scott? I can't read it on my phone.
You want me to read it?
Yeah, please.
Okay, no problem. And this is a veterans reemployment program. It says must have completed a veterans reemployment program, subchapter H142A, and next is successfully completed all conditions of program, straight or deferred. A regular jail conviction or a fine is not going to entitle them to non-disclosure. It also has to be in the best interest of justice. Note, the 2 basic requirements need not be met. It does not matter if they pick up other offenses while on probation, as long as it does not get them revoked. Also, it does not matter if they have a prior family violence or an offense that requires sex offender registration. I know that this information seems to contradict some of the stuff we're already saying, but just please keep in mind the designation of these cases. This is in Veterans Court. So that deals with persons who have been coming out of the military and qualify to go to Veterans Court. So the rules are different. Previously, we gave you examples of persons who were not in Veterans Court. That's why it seems like the rules are different. Where the cases are handled also plays a very big part as to whether or not a non-disclosure is available and or granted to a person. Can you read this, Fee? Are you ready?
Okay, yes, thank you. For human trafficking, compelling prostitution, if an individual is convicted or placed on defer for an offense under Penal Code 31.03, which is a Class B or C theft, 43.02 prostitution, or Health and Safety Code Section 481.120 and 4081.121, a Class B delivery or possession of marijuana, is requested by the prosecutor to assist in investigation or prosecution for human trafficking or compelling prostitution, and they must have participated in an investigation or could not help due to age or disability. I can tell you there have been often times where an individual has not assisted with an investigation of prostitution or trafficking, and the case was still able to be non-disclosed. So please don't let that deter you from filing a petition for non-disclosure under this statute because you feel that the individual has not participated in the investigation or is unable to participate. There have been many times these cases are still non-disclosed under this statute. To continue, the individual must prove that the defendant committed the offense solely as a victim of human trafficking or compelling prostitution, and they must show that it's in the best interest of justice for these cases to be non-disclosed. Now, an individual can file multiple petitions for different offenses, but only if no more offenses are committed. So let's say you have a client who has 15 prostitution cases. And so you want to get all those non-disclosed. So you can file a non-disclosure for all those cases. But if she picks up another offense after that, after these 15 cases have been filed, then it's going to be a problem. And so in the example, it says if an individual has 15 cases because they are a victim and petitions are filed for all 15 cases in their respective courts, if she or he picks up an additional case, they cannot get subsequent offenses non-disclosed. So they might get those 15 non-disclosed, but they pick up subsequent offenses because they pick them up after these 15 cases, then they will not be able to get those cases non-disclosed.
We have another example for you. Let's say in 2010, Mr. Kruger pled guilty to the felony theft charge and received a sentence of deferred adjudication for a 5-year term. In summary, he stole television from Best Buy. He completed his sentence without incident, and he has no other arrest and or criminal conviction. During his sentence, however, he did receive a traffic citation that was only punishable by a fine. Should the state oppose his request for non-disclosure? No. Freddie may have been wielding those blades and moving faster than the law allows on the Class C, but does not make the theft charge eligible for non-disclosure. So we're just trying to make a point here is the fact that this is a classic example of a person who may have entered a plea of guilty to deferred adjudication on the felony level, did everything that was asked of him, stayed out of trouble, and this is a non-violent offense. This seemed like something that would be a classic reason which one should be able to get that non-disclosed.
Drug courts. So notice to the state in a hearing on whether the defendant is otherwise entitled to the petition and whether issuance of the order is in the best interest of justice. For offenses committed prior to September the 1st of 2013, they must have never been previously convicted of any felony and not convicted of any other felony during the 2 years following the participant's successful completion of the program. Now that's for offenses committed prior to September the 1st, 2013. For offenses committed on or after September the 1st of 2013, the individual must have never been previously convicted of a 3G offense, an offense listed in Article 42A.054, a sexually violent offense, and not convicted of any felony during the 2 years following the successful completion of the program. Specialty courts. So there's provisions in the government code that provide that a person who completes either a drug court program or a commercially sexually exploited persons court program is eligible for an order of non-disclosure as if the defendant had received a discharge and dismissal from deferred adjudication. And you can find that under the Texas Government Code, section 123.001B and 126.001B. And that's what we spoke about earlier regarding the human trafficking non-disclosures and the drug courts.
We have another example for you here, just to put in application some other things that Ms. Kearney has already covered. Let's talk about Mr. John Rambo. In 1982, Mr. Rambo was honorably discharged from the U.S. Army after 20 years of service. In October 2017, John Rambo began his 1-year deferred adjudication sentence for criminal trespass as a participant in the Veterans Treatment Court Program. Upon review of his case, the state learned that Mr. Rambo kicked in the door of his neighbor's house and fired multiple rounds from his AR-15 because of loud music. The victims did not want to cooperate in the prosecution of the case and moved to Paris, France. Because of that, the state dismissed the aggravated assault with a deadly weapon charge and filed a case for criminal trespass. Should the state oppose the petition? Yes. It must be shown that it's in the best interest of justice that the case not be disclosed. Not disclosing a case where an individual kicks in someone's door and sprays a room with an AR-15 because the music is too loud is definitely not in the best interest of justice. And what we were trying to display in this example is the fact that you may have a situation where your client may be convicted of what may seem to be a simple offense or a small misdemeanor or something, and the state may object. The reasons for that objection may be because the state may have looked at the entire file and saw something that stood out to say, you know what, this case was reduced for A, B, and C, and that's why we're going to oppose that. So this is an example.
So the filing of a non-disclosure. So you must file the petition with the clerk of the court that sentenced the defendant or place the defendant on community supervision. The statute does not require any specific information, but you want to make sure that you include enough information to identify the records. So their name, date of birth, arrest date, date of discharge, offense, or etc. And for individuals who are not familiar with what that form looks like, you can Google it, and on the internet, you can find a petition for non-disclosure, which is pretty much very self-explanatory. So I know there's been times where attorneys have reached out and they're like, hey, this is my first time doing it. Can you kind of direct me to where I can find it? You can find it on the, you should be able to find it on the Texas Supreme Court website. But if not, like I said, you can just Google it and you'll be able to find that template. And also when you file the petition, it's very important that you include an order so that the judge has it to sign, because when petitions are filed and there's not an order, then it stays outstanding until the order is signed by the judge. So in order to expedite the process, I would suggest that when you file your petitions, that you also file an order with it. So the effects of your non-disclosures. So within 30 days of receiving notice from DPS, agencies must seal the records. The agency may not release information except to the petitioner, other criminal justice agencies for criminal justice purposes, and a list of exempt agencies. The petitioner cannot waive the non-disclosure. So let's say, for example, the petitioner wants to join the military. And so he tells the recruiting officer, well, you're more than welcome to go get my records. They cannot waive their right to non-disclose. Giving non-disclosed information to an Army recruiter, they are unable to do. Only the petitioner is able to get his records. Once an order of non-disclosure is issued, the person whose record is sealed is not required in any application for employment, information, or licensing to state that he or she has been the subject of any criminal proceeding related to the information that is the subject of the order. Both the court and criminal justice agencies may disclose sealed information.
We have another example for you, just again to put in application some of the things we'll cover during the course of this presentation. In 2015, Mr. Diesel was convicted of a misdemeanor DWI and sentenced to a term of 1 year probation stemming from an accident whereby he was involved in a traffic accident and blew a .09 at the scene. Per the police reports, he was driving fast and furious when he struck another vehicle. It should be noted he had a passenger in the vehicle with him. He has no criminal history and he has successfully completed his sentence. Should the state oppose his petition? Yes. The offense that XXX is trying to get non-disclosed resulted in an accident which involved another person, his passenger. As a result, the case is not eligible for non-disclosure.
And Scott, before you go over the flow chart, I want to, I also forgot to mention that when you have a case that is indicted under a one cause number, and let's say that that cause number is dismissed and it's re-indicted under another cause number or a lesser charge, when you file your petition for non-disclosure, once everything is disposed of, you're going to want to include the old case number as well as a new case number in that petition for non-disclosure. So you won't file just the case number where the individual disposed of that case. If there was a case number prior to that where the charge was reduced, then you are going to want to include both of those cause numbers in that petition for non-disclosure. Okay, thank you.
No problem. And what we have here is a flow chart. What this is, folks, is essentially everything we covered in a step-by-step process to help you out. I know we threw a lot of information at you, and it's a lot to digest in one sitting. And I think this flow chart does a very good job in showing you how everything works together. If we could start in the upper left-hand corner where it says, was the person convicted of the charge of the offense? You go to the next one, it says no. Or you see it says yes. If it says yes, it goes to the red box. The person is not eligible for non-disclosure. Then you go where it says no. Has a person successfully completed deferred adjudication, probation of the offense? If the answer is no, you go to the red box. If the answer is yes, you continue to go. Has the case been discharged and dismissed by the court? If the answer is no, it still go to the red box. If it's yes, you continue to go. During the period of deferred adjudication, did the person get placed on another deferred adjudication or conviction of any criminal offense greater than a fine only of a misdemeanor? If the answer is yes, you go to the red boxes, and if it's no, then you continue on. Has the person ever been required to register as a sex offender? If it's no, you continue. If it's yes, you see that still, you go to the red box and it's no, not eligible. If it's no, it's has the person ever been convicted or placed on deferred adjudication for aggravated kidnapping? If it's yes, it's not eligible. Then if it's no, you continue to go on. Has the person ever been convicted or placed on deferred adjudication for criminal homicide? And again, it gives the list of those offenses that are formerly known as 3G offenses. And as we went through these orange boxes, we talked about deferred adjudication, but keep in mind, as Ms. Kearney covered, there are DUI misdemeanors where there are conviction for that, or deferred adjudication where you may be eligible for a non-disclosure. But we're just showing you how we can streamline the majority of these cases, and mostly we're talking about here is felony offenses where an individual is placed on deferred adjudication. Please be mindful, if a person enter a felony plea and receives a bona fide probationary sentence, that is not eligible for a non-disclosure. Felony probation for deferred adjudication is what we're talking about here. And remember, the wait is 5 years. So that's what we're talking about here predominantly with this, this presentation. So if you continue on, you go through the 3G offenses, you go down. Has this person ever been convicted or placed on deferred adjudication for any offense involving family violence? If the answer is yes, the person is not eligible for a non-disclosure. And if the answer is no, you continue on. You may recall, as Ms. Kearney covered in information, that an affirmative finding of family violence is not necessary. So what happens is a prosecutor can read the case and see that it's a family violence case, and perhaps for negotiation reasons, the person did not enter a plea to the family violence finding. That may very well prevent a person from receiving a non-disclosure. But as we lawyers know, there's negotiations with everything, and it just doesn't mean that you perhaps shouldn't file it. I mean, there are individual cases, and these cases are done on the individual basis. And the best recommendation we can give to you is, hey, as the old saying go, a closed mouth does not get fed. So if you want to see if you can get a petition granted, you can go ahead and file it and see what happened. Ms. Kearney, I can continue on with the slideshow, but if you could just interject a little bit about your time as our non-disclosure persons and some of the things that you received and how you went about your decision process.
Mm-hmm. And so as far as in that's concerned, as far as in the affirmative finding of family violence, I would always pull the case because I want to review the case. I want to review the facts of the case. And oftentimes I would request that it be set for a hearing because honestly, when I've had a case where it's been fairly old, I want to know what the petitioner has done since then. And I want to know, I want to get that on record so they can say, you know what, since then I've done X, Y, and Z. I've turned my life around. I've done this, I've gone to school, I've gotten my associate. I volunteer here, I volunteer there. And so as Mr. Wells was saying, it's not an end all whenever we see something like that, as far as in a case that involves family violence. When I was working with the DA's office, I took each case individually, a case-by-case basis. And so I agree with Mr. Wells that even though you may have a case that involves affirmative finding of family violence or it involves family violence, I still would recommend that you file the case because the cases are evaluated on a case-by-case basis, and there's a possibility that there may not be an objection to the petition.
And since you're no longer employed here, I guess you're safe. Can you give us some examples of situations whereby you received non-disclosures and you thought it was a good idea, perhaps grant or not oppose, right? From the prosecution standpoint, not oppose a non-disclosure?
I can tell you a case that I had where it was an aggravated robbery. It was a robbery, and the guy shot a guy, and the young man was 19 years old, and his attorney presented to me information upon information upon information about how this young man has completely turned his life around, where he had gone to school, he had gotten his degree, he worked with young people, he volunteered. I mean, when I tell you that this man took probation seriously, and he completely turned his life around and was a role model for a lot of other people. In that situation, I will say that I did file an objection because of the nature of the offense. But speaking frankly, what I did was I said, well, hey, this is what I want to do. I want to put it on record what this gentleman has done since he has turned 19. Because at the end of the day, you still had an offense that was serious, but you also had an individual who deserved a second chance. And so we had a hearing, and at the hearing, I kind of asked him some questions because I wanted to put it on record that everything that he has done to justify him getting a non-disclosure. And so regardless of the offense, as long as it does not fall, as long as it meets the basic requirements, I would recommend and suggest that you file that petition for non-disclosure, because you don't know, what may happen. Because like I said, they are viewed on a case-by-case basis, and everybody deserves a second chance.
And I think Ms. Kearney did an excellent job when she was our point of contact for non-disclosures. And I think what she relayed perfectly is the idea that it's not lost upon us prosecutors that we are dealing with human beings, and how such a non-disclosure can actually change someone's life as far as employment and just other matters going forward to live a productive life where they don't have to answer to a felony conviction. But again, I mean, we are put in a situation where there's only so much we can do. I mean, if a person commits a 3G offense or something real nasty, we have to oppose it, we will. But again, I think if it's a situation whereby you think a non-disclosure is warranted and you think you can back it up, then perhaps you should apply for it and see what happens. And I hope this information that we've given you today will help you with your process of doing that for the people you represent. The next box is this person seeking to non-disclose a felony? And again, that's what I tried to make a distinction. I tried to make Ms. Kearney and I tried to make two distinctions in doing this presentation. The first thing, there's a huge distinction between applying for a felony non-disclosure and a misdemeanor non-disclosure. Secondly, in certain jurisdictions, in certain counties rather, the placement of the court of the case also matters. If you're going to apply for a case that came out for a non-disclosure that came out of a drug court or a veterans court, those have different parameters than a standard theft case, like we gave you an example with Freddy Cougar. Freddy Cougar will be handled differently than Rambo, and so on and so forth. And I hope that example, I hope you guys understand my example. But the next box says, if the answer is no, you go up to the yellow box where it says the offense is eligible for non-disclosure, but a 2-year waiting period from the date of the discharge and dismissal is required. Has the 2-year period elapsed? If the answer is no, boom, you go to the red box. If yes, you go on. But keep in mind, the yellow box is talking about misdemeanors because it said 2 years. If you go back down to the bottom where it says, is this person seeking to disclose a felony? If the answer is yes, then you go to that big wordy box right there and it says, is the offense sought for non-disclosure, unlawful restraint, kidnapping? And it gives you a number of offenses for you to go through. And if the answer is yes, if it's one of these offenses in the biggest box, you see where it says yes, and it goes to this person is not eligible for a non-disclosure. If the answer is no, you will then circle onto the yellow box, and it says the person is eligible for a non-disclosure, but a 5-year waiting period from the date of the discharge and dismissal is required. Has the 5-year period elapsed? And if it's yes, and it says this person is eligible for to file a non-disclosure. And just keep in mind, one thing that we also want to make abundantly clear is that it says this person is eligible to file it and hopefully get it granted. This doesn't guarantee a grant of a non-disclosure. I mean, for example, Fee and I are prosecutors who would probably grant a non-disclosure for Freddy Krueger, but you may get a prosecutor to say, you know what, it's Freddy Krueger, I'm not granting it. You know what I mean? And they may oppose it, and they may try to put reasons out to why they don't want to do that. So we don't want to give the impression to anyone that anything is automatic. We all know that it's subject to the judge's decision. But I think if you have a strong leg to stand on once you go through the facts of your case, whereby you have a client who has done everything that was asked of them, and they've remained conviction-free during the time of the deferred adjudication sentence. I think that example is worth repeating. Just keep in mind, if a person goes on deferred adjudication in 2010 and has deferred to 2015, even if they committed an offense in 2007, if they plead to that 2007 offense during the time of their new non-disclosure period of the 5 years, then they're not going to be eligible for the non-disclosure in the new case. It's because you've got a new conviction during your deferred adjudication sentence for the other case. And some people misunderstand that, and it can be very, very devastating to a defendant who relied on his or her attorney's advice and entered a plea to something that may have occurred before. And they say, well, it happened before, but well, no, you violated the terms of your deferred adjudication by getting a new conviction. Is there anything you want to add to, Steve, you think I missed? Or Ms. Excuse me?
No, I just wanted to follow up on what you mentioned earlier when you said that it may be a situation where the non-disclosure may not be granted, where there may be an objection filed by the state. And what I would suggest is that if there is an objection, but once again, if your client's case meets the base requirements, but yet they qualify according to statute, and maybe the state objected for the best interest of justice, I would go ahead and set that immediately for a hearing. And that's something that you want to make sure that you do. I know that everybody's extremely busy. I know that you have a number of cases on your plate, but you want to make sure that if there's an objection and your client still qualifies, that case qualifies. Once you get that objection and it qualified, just go ahead and send an email to the court and say, hey, this case, I received the state's response, and I want to set a hearing to be heard on this petition. And then that's when you lay everything on the line. Like I said, you bring in everything, including the kitchen sink, on how wonderful your client is and how much they've changed and why they deserve a non-disclosure and how it's going to be in the best interest for the client and the community that he gets a non-disclosure. Because guess what? If that case is not disclosed, like Scott was saying, that will prohibit him from getting a job, employment, or housing, or being a productive citizen. So if you get an objection, go ahead and set it for a hearing and let the judge hear the case and let the judge decide. But don't just stop right there and just throw in the towel.
All right, thank you. Let's see what we have next. This is our last slide. A huge thanks. I think at this point, I think we have roughly 4 minutes left. I don't know if we have any questions in the inbox. I don't have my inbox up. I was trying to the chat section, and should I look in the chat? Is there any questions there? I don't see anything there.
Yeah, I can't. Let me see. I don't think so.
Martin, do we have any questions or anything?
Or Maricela?
No questions have come in that I can see. Everything is good. So thank you both, Mr. Wells and Ms. Kearney, for being here this afternoon. Of course, I will pass along your contact information for anyone who may have a follow-up question. But I also want to, we do have So a copy of the presentation will not be provided, but if you do have specific questions, you can contact Mr. Wells or Ms. Kearney. As far as CLE
We'll send the
credit.
flow chart to you, Chris.
Oh, perfect.
I'm sorry,
Thank
we'll
you.
send the flow chart to you. That would be, I think that would be helpful. I think that pretty much sums up everything, is that flow chart that's got
Perfect.
created.
So they will be sending around the flow chart. And if they send it to me, then I can also disperse it amongst attendees. So thank you very much. And I also want to direct your attention to the chat box. I do have the MCLE course credit number in there. And we ask that everyone self-report their MCLE course credit. And I'm just going to say it real quick. 174-165-985. Again, that is 174-165-985. And I don't see any additional questions in the chat or the Q&A. So again, Mr. Wells, Ms. Kearney, thank you so much for your time this afternoon and for a great presentation. Always a lot of good information for our attorneys. And we
Thank you for having us.
Thank
Glad to
you.
be here. And
Thank you,
thank you,
Scott.
everybody, for joining in.
Awesome. Well,
Thank you.
everyone,
Yes,
have
thank
a
you,
good
everybody.
rest of your afternoon. And if you have any questions, please feel free to reach out to me or Mr. Wells or Ms. Kearney. Goodbye.
Bye-bye.
Thank you.